There is a driveway in Tallahassee, Florida, a quiet street called Trescott Drive, a two-car garage with a basketball hoop bolted above it, toys on the lawn from the night before, the kind of house you drive past 1,000 times and never remember. On the morning of July 18th, 2014, at 11:26 in the morning, a neighbor heard what she thought was a car backfiring. Two quick sounds. She looked out the window. Nothing. She went back to her coffee. 4 minutes later, a silver Toyota Prius with Florida plates rolled out of the cul-de-sac, accelerated past the stop sign, and disappeared toward the interstate. Inside the garage of 2116 Trescott Drive, a 41-year-old man was slumped against the driver's door of his own car, with 2 bullet wounds in his head. He had just dropped his 2 young sons off at daycare. He had just come back from the gym. His gym bag was still on the passenger seat. His phone was still in his pocket. His wedding ring had been removed 16 months earlier when his divorce was finalized, but the tan line was still visible on his finger. His name was Daniel Eric Markel. He was a professor of criminal law at Florida State University. He had published books about punishment and ethics and moral philosophy. He had clerked for a federal judge. He had degrees from Harvard and Cambridge and the University of Toronto. He was 41 years old, and somebody had just executed him in his own garage in broad daylight on a Friday morning, in front of a basketball hoop that his sons used on weekends. There was no robbery. His wallet was on him. His laptop was on the kitchen counter. The house had not been entered. The killer did not know him, did not speak to him, did not ask him anything. The killer walked up to the driver's side of the vehicle, fired twice through the glass, turned around, got into the Silver Prius that was waiting at the curb, and drove 900 miles back to Miami. Miles, ghost hunter here. This is the case of Dan Markel, a man who taught criminal law for a living and became the subject of the most complicated murder-for-hire investigation in the history of the state of Florida. A case that took 10 years to resolve. A case that climbed, one conviction at a time, from 2 hired gunmen in Miami all the way up to a 70-year-old grandmother in a gated community who tried to flee the country with a one-way ticket to Vietnam. A country, I should mention, that has no extradition treaty with the United States. This is a story about how a bitter divorce between 2 highly educated people became a conspiracy between a family of wealthy South Florida dentists to kill the father of their grandchildren. It is a story about the absolute conviction on the part of people who had everything that they were smart enough to get away with murder. And it is a story about the FBI operation that finally cracked the silence, a fake extortion scheme, a $10,000 bag of cash dropped in a parking lot, and a recorded phone call between a son and his mother in which they discussed what they called the plan. But before we get to any of that, you need to know who Dan Markel actually was, because you cannot understand this case without understanding what kind of man was taken from that garage. And you cannot understand what kind of man he was without going back 13 years before the morning he was shot. Dan Markel was born in Toronto, Canada, in 1972. His parents were Ruth and Phil Markel, both Canadian, both deeply involved in the local Jewish community. Dan was the older of 2 children. His younger sister, Shelley, would later become one of the most important voices in the fight to get justice for her brother. The Markels were not wealthy. They were educated, disciplined, religious, and they believed in the idea that intellectual work was a moral calling. Dan showed up to the world as an intense, verbal, relentlessly curious child. He was the kind of student teachers remember decades later. He read constantly. He argued constantly. He did not argue the way some children argue, to be right or to get his way. He argued because he genuinely wanted to understand why things were the way they were. He wanted the logic. He wanted the ethics. He wanted the rule beneath the rule. He went to the University of Toronto for his undergraduate degree. He finished there in 3 years instead of 4, because Dan did not really do things at normal speed. He then went to Cambridge, in England, for a master's degree in religious studies. From Cambridge, he went to Harvard Law School, graduating in 1998. After Harvard, he clerked for Judge Michael Daley Hawkins on the Ninth Circuit Court of Appeals. He worked in private practice in Washington, D.C. for a few years, doing white-collar defense work, and then he made the decision that would define the second half of his life. He decided to teach. He joined Florida State University's College of Law in 2005. He was 32 years old. Within a few years, he was one of the most cited young legal scholars in the United States. He founded a blog called Prof's Blog, which became the single most influential online forum for law professors in the English-speaking world. He wrote papers about retributive justice, the philosophical idea that punishment is morally justified, not because it deters future crime, but because it expresses a community's judgment that wrongdoing must be answered. He wrote about mercy. He wrote about forgiveness. He wrote about the limits of the state's power to punish. He was, by every account, an electric teacher. His students either worshipped him or complained about how intense he was, and sometimes both, from the same student in the same semester. He called on people cold. He pushed them. He laughed at his own jokes. He stayed after class for hours to keep arguing with anyone who wanted to keep arguing. He was short, energetic, a little prematurely balding, and he had a particular kind of laugh that people who knew him remember immediately. It was loud. It filled a room. In 2006, 1 year after he started teaching at Florida State, he met a woman named Wendy Jill Adelson. Wendy was a Jewish woman from Coral Springs, Florida, a wealthy suburb north of Fort Lauderdale. She was smart. She had degrees from Brandeis and Cambridge and the University of Miami School of Law. She ran an immigration law clinic. Her family was affluent in a specific, very recognizable South Florida way. Her father, Harvey Adelson, was a dentist who had built a successful practice called the Adelson Institute. Her mother, Donna Adelson, was a strong-willed matriarch who had raised her children with a clear and non-negotiable message: the family is everything, and the family's interests come first. Wendy had an older brother, Charles Adelson, known to everyone as Charlie. Charlie was also a dentist, eventually taking over much of the family practice. And Wendy had a sister, Rebecca, who stayed largely out of the spotlight. Dan and Wendy got married in 2006, the same year they met. It was, by the accounts of everyone who was there, a genuinely happy wedding. Two bright, ambitious, educated Jewish professionals starting a life together. They moved to Tallahassee. They bought the house on Trescott Drive. They had 2 sons. The older son was born in 2009. The younger son was born in 2011. And then, somewhere between 2011 and 2012, the marriage broke. I am going to say something important here. What actually happened inside that marriage is something only 2 people fully knew, and one of them is no longer alive to tell his side of it. There are versions. There are accusations. Wendy has said, in court and in her own writing, that Dan was controlling, obsessive, difficult to live with, that he had rigid expectations about religious observance and family behavior. Dan's friends and family have said the opposite, that Dan was devoted to his sons, that he adapted to Wendy's demands, that he wanted the marriage to work and was devastated when it fell apart. What is not in dispute is this: Wendy filed for divorce in September of 2012. The divorce became final in July of 2013, about 1 year before the murder. And from the moment the divorce was filed, there was one issue that dominated everything else. One issue that Wendy's family, specifically her mother, Donna Adelson, could not accept: the children. Wendy wanted to move back to South Florida with the 2 boys. She wanted to move to the Adelson family compound in the Miami area. She wanted her children near her parents, near her brother, near the wealthy dental practice that funded everything the family did. She wanted, in her own words, to go home. Dan said no. Dan said no for a reason that every divorced father who has ever fought a custody case will understand instantly. If Wendy moved to Miami with the boys, Dan's role as a father would effectively end. Tallahassee to Miami is a 7-hour drive. It is a flight plus a rental car. It is not the kind of distance a weekend father can bridge twice a month with 2 small children. Dan wanted his sons. Dan wanted to see them grow up. Dan wanted to read to them at bedtime, not on a FaceTime call, but in the same room. And Dan understood something about the Adelson family that nobody wanted to say out loud, that the grandmother, Donna, did not really want her daughter to have the children. Donna wanted the children to have the grandmother. The custody fight became, over the course of 2013 and early 2014, one of the ugliest legal battles that the Tallahassee family court had seen in years. There were motions and counter-motions. There were allegations about parenting fitness. There were email chains that later became evidence. At one point, Dan filed a motion to prevent Donna Adelson from having unsupervised contact with her own grandchildren, arguing that she had been bad-mouthing him to the boys, coaching them, trying to undermine his relationship with them. A judge partially granted it. This is the point at which something shifted inside the Adelson family. This is the point at which the conversations around the dinner table stopped being about custody and started being about removal. This is the point. And we know this because of what was recorded years later, at which the matriarch of the family, Donna Adelson, began to believe that Dan Markel was a problem that needed to be solved. Not negotiated with, not outlasted, solved. In April of 2014, about 3 months before the murder, Charlie Adelson was living in an apartment in Fort Lauderdale. Charlie was 39 years old at that time. He was a bachelor. He was a practicing dentist in the family business. He drove expensive cars. He dated a lot of women. He was, by several accounts, the favored child in the family, the son Donna could never quite let go of. One of the women Charlie was dating in early 2014 was a woman named Catherine Magbanua. Catherine was 30 years old. She was Filipino-American, strikingly beautiful, with long, dark hair and a calm, almost watchful quality that struck people immediately. She had 2 children with a man named Sigfredo Garcia. Sigfredo was in his early 30s, heavily tattooed, a man who had grown up in Miami's rough Latin neighborhoods and who had spent much of his adult life running with a gang called the Latin Kings. Catherine and Sigfredo were not technically married and not technically still together, but they shared children and a complicated ongoing relationship. Charlie Adelson met Catherine, according to the evidence that would later emerge, at a strip club in Miami where Catherine worked. Charlie liked her. Charlie began seeing her. Charlie also liked the fact that Catherine had connections to a certain kind of man, a man like Sigfredo Garcia, the kind of man who, if asked in the right way, for the right price, might be willing to do something that Charlie Adelson, dentist and gentleman, could not do himself. In the first week of July 2014, an arrangement was made. I want to be careful here about the language I use, because what I am describing is a conspiracy that was reconstructed years later, from phone records, financial records, surveillance footage, recorded conversations, witness testimony, and the ultimate breaking of one of the participants. At the time it happened, nobody but the people inside it knew it was happening. The state of Florida would not be able to prove it until 2022. But here is what the reconstruction eventually established. Sigfredo Garcia was approached, through Catherine Magbanua, with a proposition. Drive to Tallahassee. Find a man whose name, photograph, home address, workplace, gym location, daily schedule, and car description would be provided. Follow him. Identify the right moment. Shoot him. Drive back. Receive payment. The payment, as discussed between Catherine Magbanua and Charlie Adelson, was to be $100,000. That figure would later become one of the most important numbers in the case, because $100,000, split among 3 people, is not actually a lot of money for a contract killing. It implied that the job was being done by people who did not fully understand what they were signing up for. Sigfredo brought in a friend, a man named Luis Rivera. Luis was also 34 years old, also a Latin king, also from the Miami area, also the kind of man with a criminal record. Luis had done some time in federal prison for unrelated charges. He was out. He was broke. He was available. On July 15, 2014, Sigfredo Garcia and Luis Rivera rented a silver Toyota Prius from a rental agency near the Miami airport. They paid with someone else's credit card information. They loaded it up. They drove north. Tallahassee is at the top of the Florida Panhandle, far closer to Georgia and Alabama than to Miami. The drive took them about 7.5 hours. They arrived on the evening of July 15th. They began doing what they had been hired to do. They began watching Dan Markel. For 3 days, from the 15th to the 18th of July, 2014, Sigfredo Garcia and Luis Rivera followed Dan Markel. They sat in the parking lot of his gym, a place called Premier Health and Fitness. They watched him drop his children off at daycare. They learned the layout of Trescott Drive. They learned what time he left for work, what time he came home, which door he used, where he parked. They ate fast food. They slept in a cheap motel. They called Catherine Magbanua to check in and to be told to keep waiting, to pick the right moment, to make sure it was clean. The morning of July 18th was a Friday. Dan Markel got up early, as he always did. He got his 2 sons ready for daycare. He put them in the car. He drove them to the daycare center. He kissed them goodbye at the door. He got back in his car. He drove to Premier Health and Fitness. He worked out for about an hour, and then, at around 11 in the morning, he drove home. Sigfredo Garcia was waiting on Trescott Drive. Luis Rivera was in the driver's seat of the Silver Prius. They watched Dan pull into his driveway and open the garage door from inside his car. They watched the garage door begin to close behind him as he pulled inside. And Sigfredo moved. He walked up the driveway just before the door finished closing. He had a handgun. He approached the driver's side of Dan's vehicle. Dan had not yet gotten out. Dan saw him. In the last half-second of his life, Dan Markel saw the man who had been hired by his ex-wife's family to kill him. And then it was over. 2 shots. Sigfredo turned, walked back out of the garage before the door sealed, got into the waiting Prius, and Luis Rivera drove them out of the cul-de-sac. The neighbor who heard the sounds looked out the window, as I said, and saw nothing unusual. The garage door had closed. The street was quiet. It was only a few minutes later, when a separate neighbor, who had been expecting to talk to Dan that day, came by the house and noticed something was not right, that the police were called. Tallahassee Police Department detectives arrived within 20 minutes. They found Dan inside his car, inside the garage. The medical examiner would later determine that death had been almost instantaneous. The scene, by the standards of violent crime, was remarkably clean. No shell casings left behind, no fingerprints, no witnesses who had seen the shooter's face. The only physical evidence was the bullets themselves, the impact on the driver's side window, and a few partial tire tracks at the curb that investigators photographed carefully and did not yet know the significance of. The lead detective assigned to the case was a man named Craig Isom, a veteran Tallahassee investigator who had handled murders before, but had never handled anything quite like this. Isom arrived at the scene and did what experienced homicide detectives do. He looked at the victim. He looked at the location. He asked himself the most important question in any murder investigation: who had a reason? The problem was that the answer, on its face, was nobody. Dan Markel was not a man with enemies in the ordinary sense. He was not involved in any business disputes. He was not in debt. He had no gambling problems, no drug problems, no affairs. He was, from what his colleagues and neighbors and friends described, a dedicated father and a serious scholar who spent most of his time either teaching or writing or with his children. The only area of conflict in his life was the divorce. And the divorce, ugly as it had been, was already over. The custody battle was ongoing, but it was a civil matter, handled through lawyers, with no history of threats of violence on either side. The police went through the obvious list. They interviewed his colleagues at Florida State. They interviewed his students, including some students who had received low grades from him, on the remote possibility that a disturbed young person had taken it personally. They interviewed his neighbors. They interviewed his friends. Every lead went nowhere. Dan Markel had been, by every account, the kind of person who made no one angry enough to kill him. Except, of course, for the family he had married into. Detective Isom and his team interviewed Wendy Adelson on the afternoon of the murder. Wendy was in Tallahassee at the time, living with the boys in a separate home. She agreed to come to the police station. Her interview, which was recorded on video and would later become one of the most studied pieces of evidence in the case, lasted for several hours. She was composed. She was articulate. She answered questions about her schedule, about her family, about the divorce, about the custody fight. She said that she had been at work all morning. She said that she had picked up the boys from daycare in the afternoon, at which point she had been told by someone that her ex-husband had been involved in an incident at his home. She cried at appropriate moments. She expressed appropriate shock. But in the middle of that interview, she said something that Detective Isom remembered for the rest of his career. She said, and I am paraphrasing here from the transcript, that her brother Charlie had once told her, in what she assumed was a dark joke, that he had looked into hiring a hitman to solve the Dan problem. He had not done it, she said. It was just something Charlie had said. Charlie said a lot of things. Her brother had a dark sense of humor. Detective Isom filed that statement away. He did not act on it immediately. He wanted to see where the evidence led. But that single sentence, a sentence Wendy Adelson volunteered, seemingly without understanding what she was doing, became the thread that the investigation would eventually pull. In the weeks after the murder, the investigation expanded in every direction. Tallahassee police received help from the Florida Department of Law Enforcement. They began pulling records, cell tower records, license plate reader records, toll booth records from the Florida Turnpike. They began looking for any unusual vehicle movement between Miami and Tallahassee in the days surrounding July 18th. And they found it. Automated license plate readers on Florida highways had captured a silver Toyota Prius, rented from an agency near Miami International Airport, traveling north on the I-10 corridor on July 15th. The same Prius was captured on cameras in and around Tallahassee between July 15th and July 18th. And then, the same Prius was captured heading south, back toward Miami, on the afternoon of July 18th. Within hours of the murder, the rental records led to a fake credit card identity, but the rental agency had surveillance video of the actual people who had picked up the car. Two Hispanic men in their 30s, one heavily tattooed. Neither of them had any connection to Tallahassee, to Florida State University, to the academic world, or to Dan Markel in any conceivable way. The investigators were now looking at a contract killing. The question was, who had paid for it? The investigation stalled, publicly, for almost 2 years. Behind the scenes, detectives were doing painstaking work, building profiles of the two men in the rental agency video, tracing the Prius, trying to identify the shooters. They got a partial break when a confidential informant mentioned, in an unrelated case, that a man named Luis Rivera, a Latin Kings member out of the Miami area, had been bragging about a big score he had done up in the Panhandle. Bragging, as it happened, was going to be the thing that ended Luis Rivera's freedom. In May of 2016, almost 2 years after the murder, Tallahassee police and federal agents arrested Sigfredo Garcia, Luis Rivera, and Catherine Magbanoa. The three of them were charged with first-degree murder and conspiracy to commit murder. The theory of the case was this: Sigfredo Garcia was the shooter, Luis Rivera was the driver, Catherine Magbanawa was the middleman, the person who had connected the shooters to the person who had actually paid for the hit. And the person who had actually paid for the hit, the theory went, was Charlie Adelson. The problem was that the state did not yet have enough evidence to charge Charlie. Luis Rivera, facing a life sentence, made the decision that Sigfredo Garcia refused to make. He cooperated. He gave a full statement. He told investigators everything he knew, which was that he had been recruited by Sigfredo, that he had driven the Prius, that he had watched Sigfredo walk into the garage and fire the shots, and that Sigfredo had told him the job had been arranged through Catherine, and that the money was coming from Catherine's rich boyfriend, who was a dentist in Miami. Rivera's cooperation was essential, but it was not enough. Under Florida law, you cannot convict someone based solely on the testimony of a co-conspirator. You need corroboration. And Charlie Adelson, through his lawyers, refused to speak to investigators. His parents, Donna and Harvey Adelson, refused to speak to investigators. Wendy Adelson refused to speak to investigators except through counsel. The family closed ranks. They hired the best criminal defense attorneys money could buy. And for the next several years, they simply waited. The first trial came in October of 2019. Sigfredo Garcia and Catherine Magbanawa went on trial together in Tallahassee. The prosecutor was Georgia Kappelman, an experienced assistant state attorney who had been working the case for years. She laid out the evidence carefully: the rental records, the cell tower data, the license plate readers, the testimony of Luis Rivera, who by this point had pleaded guilty and was testifying against his former friend. The financial records showing that Catherine Magbanawa had received significant cash payments from Charlie Adelson in the weeks and months after the murder, supposedly as payment for working at the Adelson Family dental practice, even though there was no evidence she had ever actually worked there. Sigfredo Garcia was convicted of first-degree murder. He was sentenced to life in prison without the possibility of parole. Catherine Magbanawa was a different story. The jury was unable to reach a verdict on her. They hung. The judge declared a mistrial. Catherine walked out of the courtroom a free woman, at least temporarily, and the state had to decide whether to retry her. They did. In May of 2022, Catherine Magbanawa was tried again. This time, the prosecution had additional evidence, more financial records, more phone records, and most importantly, a piece of evidence that had not been available at the first trial. Evidence that came from an FBI operation that had taken place just 1 month earlier. An operation that would turn out to be the moment the case against the Adelson family finally cracked open. Let me explain what the FBI did. In the spring of 2022, federal agents working with Tallahassee investigators decided to run what is called a bump operation. The theory behind a bump is simple. You have a target who you believe is guilty, but who has not made any incriminating statements in 7 or 8 years. You need to make that target nervous. You need to make them talk. So you introduce an artificial stressor into their life, something that will panic them into making a phone call they otherwise would not make. The FBI hired an undercover agent of Russian descent, a man who spoke with a slight accent. The undercover agent approached Donna Adelson on the sidewalk outside her apartment building in the Aventura area of South Florida. He handed her a note. The note said, in effect, that the writer knew what the family had done to Dan Markel, and that for a payment of a large sum of money, the writer would keep silent. If the payment was not made, the writer would go to the FBI. Donna Adelson took the note. She went inside. She called her son Charlie. Charlie came over immediately. And then, over the next several days, Charlie Adelson and Donna Adelson had a series of phone conversations that were, unbeknownst to either of them, being monitored and recorded pursuant to a federal wiretap order. These recordings are the most important pieces of evidence in the entire case, because on these recordings, Charlie Adelson and Donna Adelson did not talk like two innocent people who had just been approached by a crazy extortionist. They talked like two guilty people who were trying to figure out how to handle a threat. They talked about how the writer of the note probably knew things. They talked about whether they should pay. They talked about whether paying would be an admission. Donna suggested at one point that they should go to Vietnam. Charlie said, and this is close to a direct quote, that paying would be an admission of guilt. They discussed, using veiled language, what Charlie had done and what Donna had known about it. At one point, Donna said that if Charlie had just listened to her years ago, none of this would be happening. Charlie responded by saying that she had been part of it too. The recordings do not contain a clean, courtroom-style confession. The Adelsons were careful enough, even under stress, not to say Dan Markel's name, not to use the word quote 4, or quote 5, or quote 6, not to describe specific acts. But the recordings contain something almost as damning, the unmistakable tone of two people who are coordinating a cover-up of something both of them already know about. The jury would later hear these tapes. So would Charlie Adelson's jury. So would Donna Adelson's jury. Catherine Magbanua was convicted at her second trial in May of 2022. She received a life sentence. The jury, this time, had heard enough. Then, in April of 2022, 1 month before Catherine's second trial ended, Charlie Adelson was arrested at his home in South Florida. He was 45 years old. He was taken into custody, booked, and charged with first-degree murder, solicitation to commit murder, and conspiracy to commit murder. He was denied bail. He went to jail and stayed there, waiting for his trial. Charlie Adelson's trial was held in November of 2023, almost a decade after Dan Markel's death. The courtroom was packed every day. Dan's mother, Ruth Markel, was there. His father, Phil, was there. His sister, Shelley, was there. Dan's sons, now teenagers, were not in the courtroom, but they were very much present in everything that was said. The prosecution's case against Charlie was circumstantial in the classical sense. There was no single witness who could say, __, quote, _7__. Luis Rivera could only say what Sigfredo had told him. Catherine Magbanua refused to testify. The physical evidence did not link Charlie to the crime scene. Charlie had been in South Florida on the day of the murder, with a verifiable alibi. What the prosecution had was a pattern of financial transfers from Charlie to Catherine in the months after the murder. A pattern of text messages and phone calls, and, above all, the recordings from the FBI bump operation. Charlie's defense attorney, Daniel Rashbaum, argued a theory that was simple and, to his credit, internally consistent. His theory was that Catherine Magbanua had acted on her own. That Catherine, perhaps hoping to win Charlie's affection or to benefit financially from the Adelson family's resolution of the custody dispute, had arranged the killing without Charlie's knowledge. That Charlie's payments to Catherine after the murder were not hush money, but ordinary payments for work she was doing. That the FBI bump operation had panicked an innocent man into making suspicious-sounding phone calls to his mother, but that suspicion was not proof. The jury did not buy it. They deliberated for approximately 3 hours. They returned a verdict of guilty on all counts. Charlie Adelson was convicted of first-degree murder. He was sentenced to life in prison without the possibility of parole, plus an additional 30 years for solicitation and conspiracy. He was 46 years old. He will never leave prison alive. And now we get to the final chapter of the case, the one that is still being written as I am recording this. Because after Charlie's conviction, the prosecution did something that many observers had assumed would never happen. They moved up the chain. They charged Donna Adelson. The charging of Donna Adelson was in many ways the moment that revealed what this case had always been about. The theory of the prosecution in charging Donna was that Donna had been the principal driver of the conspiracy from the beginning. that it had been Donna who could not accept her daughter's inability to move to Miami with the grandchildren, that it had been Donna who had pressured Charlie to do something about Dan. That Charlie, in effect, had carried out his mother's wishes. The FBI recordings were the spine of this theory. On those recordings, it was Donna, not Charlie, who sounded like the one giving instructions. It was Donna who had pushed for Vietnam. It was Donna who had reminded Charlie that she had been part of it, that she had told him to handle things differently, years ago. In November of 2023, shortly after Charlie's conviction, federal and Florida law enforcement officers converged on Miami International Airport. Donna Adelson, 73 years old at the time, had booked a one-way flight to Vietnam. Her husband Harvey was traveling with her. She was stopped at the gate. She was informed that she was under arrest for conspiracy to commit murder, solicitation to commit murder, and first-degree murder. Her travel plans had not been a coincidence. Vietnam does not have an extradition treaty with the United States. Donna Adelson, in the view of the prosecution, had been preparing to flee. Donna's trial began in the fall of 2025. As I am speaking to you, the proceedings are ongoing. She is an elderly woman. She is wealthy. She has the best defense lawyers money can buy. She has maintained, throughout every interview and every filing, that she had nothing to do with her former son-in-law's death, and that the FBI recordings are being misinterpreted. Whatever the verdict turns out to be in Donna Adelson's case, the structure of the case is now clear. It goes up one side of a family and comes down the other. Sigfredo Garcia, the shooter, convicted. Luis Rivera, the driver, cooperated. Catherine Magbanoa, the middleman, convicted. Charlie Adelson, the financier and the link to the family, convicted. Donna Adelson, the matriarch and, according to the state, the originator, on trial. One person in the center of this story has never been charged: Wendy Adelson, Dan's former wife. The mother of Dan's children. The state of Florida has said, repeatedly, that there is no evidence that Wendy knew in advance about the plan to kill her ex-husband. There is no recording of her discussing it. There are no financial records linking her to the payments. There is no testimony from anyone placing her inside the conspiracy before July 18th of 2014. Wendy has consistently maintained that she had no knowledge. The prosecution has consistently said that they cannot prove otherwise. What Wendy has said she felt, and what she has written about, is that she came to understand slowly and with great horror that the people she loved most in the world had killed the father of her children. She has testified in the trials of her brother and mother. Her testimony in Charlie's trial, where she sat a few feet from her own brother and was asked about conversations within her family, was one of the most difficult moments of the entire legal proceeding. She was asked whether she remembered joking with her brother about hitmen. She said she did. She was asked whether she had believed at the time that her brother was serious. She said she had not. Dan Markel's two sons are now teenagers. They were 4 and 6 years old when their father was shot in the garage of their home in Tallahassee. They have grown up in South Florida with their mother, and for most of their childhood, with regular contact with their grandmother Donna, the grandmother who is now accused of arranging their father's murder. They have lost their father, and they are now, one by one, losing their extended family to the legal system that their father spent his career thinking about. Dan's mother, Ruth Markel, became one of the most visible and effective advocates for her son's memory. She wrote a book about the case. She pushed Florida legislators to pass what became known as Fagie's Law, later modified and expanded, which addressed grandparents' rights in cases where a parent has been killed. She spoke at nearly every major court hearing. She sat in the front row of every trial. She watched every verdict read aloud. Dan's father, Phil Markel, passed away in the years between the murder and the final convictions. He did not live to see Charlie Adelson found guilty. He did not live to see the arrest at the airport. He carried the weight of his son's death for the rest of his life, and the resolution came, in parts, too slowly. One of the reasons this case ended with convictions at all. The state of Florida prosecuted it, but a family kept it alive in the public mind long enough for the prosecution to succeed. Now let me tell you what I think this case means. Because it is easy, when you hear a story like this, to reduce it to its most shocking surface. A dentist hires a hitman. A grandmother plans to flee to Vietnam. Wealthy people think they can buy their way out of consequences. All of that is true, and all of that is part of the story. But none of it is actually what the Dan Markel case is about. The Dan Markel case is about what happens when a family comes to believe that its internal needs outweigh the rest of the moral universe. It is about the specific, corrosive logic that takes hold inside a certain kind of family where the matriarch has decided that her grandchildren belong to her and not to their father. It is about the way a custody dispute, a purely legal disagreement that millions of families navigate every year without violence, can become reframed over months and years as a problem with a human obstacle. And it is about the specific distance from that reframing to the decision to remove the obstacle. Dan Markel spent his career thinking about exactly this kind of moral collapse. His academic work was focused on what philosophers call retributive justice, the idea that when a wrong is done, the community has not just a right but a duty to respond, not for revenge, not even for deterrence, but because the act of refusing to punish is itself a kind of failure. A failure to say, as a society, that this should not have happened. In a way that nobody involved in this case ever imagined when it started, Dan Markel became a test case for his own theory. The state of Florida spent 10 years pursuing the people who killed him. It spent millions of dollars. It dealt with hung juries and appeals and delays, and a family of defendants who fought every step of the way with the best legal resources available. And in the end, it arrived at the conclusion that Dan's scholarship would have predicted. It arrived at judgment. There is something almost unbearable about thinking of Dan in those final seconds in the garage. A man who had spent his adult life thinking carefully about the ethics of punishment, face to face with a man who had been paid by his own children's grandmother to end his life. A man who had published papers about mercy and forgiveness, killed by people who had decided that he was simply in the way. A man who had 2 young sons waiting for him to come home that night. But I want to end by telling you what Dan's colleagues and friends have said over and over again since July of 2014. They have said that Dan would have wanted the case prosecuted rigorously, but that he would not have wanted it to become the only thing he was remembered for. They have said that Dan's scholarship is still read, that his students still teach, that the blog he founded, Prof's blog, is still active, that his ideas about punishment and mercy are still being argued about in law school classrooms around the world. Dan Markel taught criminal law. He taught it seriously, and he taught it well, to thousands of students over the course of a decade. And when people who had been in his classes heard, in 2014, what had happened to him, many of them said the same thing. They said that he would have taken notes, that he would have wanted to understand the mechanics of it, that he would have asked questions about motive and intent and the moral structure of the conspiracy, that he would have wanted, above all, to turn it into a case, something you could study, something you could learn from, something that would outlast the people who had done it. His last lecture was the one he did not give. His last case was the one the state of Florida built against his own killers. Over a decade, witness by witness, conviction by conviction. And every single student who sat in a Florida courtroom over those years and watched those trials unfold received an education that Dan Markel would have recognized. An education in exactly the questions he had spent his life asking. What do we owe the victims of the worst things human beings do? What is the community's duty? What is the difference between forgiveness and surrender? He did not live to answer those questions in his own case. But the answers came anyway. Slowly, imperfectly, delayed. But they came. I want to take you back now one last time to the morning of July 18th, 2014. Not because I want to linger on what happened in the garage, but because I want you to understand what else was happening in the world that morning. What Dan Markel had been doing the day before. What he was planning to do that weekend. What he was going to do the following Monday. He had been preparing for the fall semester. He had a new course he was going to teach, a seminar on punishment theory, and he had been writing the syllabus in the evenings after the boys went to bed. He had a paper draft on his laptop that he had been working on for months. A paper about the concept of what he called Quote 9, which is a fancy way of saying the idea that when a wrong is done, the community must stand up and face the wrongdoer directly, rather than simply managing the situation administratively. That paper, which he never finished, was later published posthumously by his colleagues, and it is, in a way that none of them could have anticipated, a kind of ghostly commentary on his own death, because the state of Florida, through its prosecutors, did exactly what Dan Markel argued the state had a duty to do. They confronted the wrongdoers. They did not manage the situation. They faced it. He had been planning to take his sons to a birthday party the following weekend. He had already bought the present. It was still wrapped, sitting on a table in his living room when the detectives arrived. He had been exchanging emails with a colleague at Harvard about a conference in the fall. The last email he sent, which was time-stamped at 10:47 in the morning on July 18th, was a polite, professional, slightly nerdy note confirming that yes, he would be happy to serve as a commentator on a panel about criminal law theory in December. He sent that email, closed his laptop, and drove to the gym. By the time the colleague at Harvard read the reply, Dan was already dead. These are the things that get lost when a case becomes a case. The small, ordinary, continuing things. The syllabus on the desk, the wrapped gift on the table, the polite email to a colleague, the basketball hoop over the garage door. The fact that on the morning he died, Dan Markel was a man who was planning his life forward, who expected to eat dinner that night, who expected to call his sons in the evening after they had dinner with their mother, who expected, above everything else, to see his children grow up. The people who killed him knew all of that. They knew about the sons, they knew about the daily routine, they knew he was a professor, not a target from some other criminal world, not a man who had any way of defending himself or any reason to suspect that he was in danger. They knew he was going to pull into his garage at around 11, exactly as he did every weekday after the gym. They knew because they had watched him. They had studied him the way he might have studied a legal problem. And they did it for a sum of money that, split 3 ways, is less than many of the people watching this video will earn in a year. That disparity, the distance between the enormity of what was taken and the smallness of what was paid for it, is one of the things that makes this case so difficult to absorb. $100,000, divided among a shooter, a driver, and a middleman, a life's work and a family's future, reduced to a wire transfer and a bag of cash. Let me tell you now about some of the things that emerged during the trials that have not gotten the attention they deserve, because the courtroom record in this case is enormous, and some of the most revealing material is buried in the testimony that did not make the headlines. During Charlie Adelson's trial in 2023, prosecutors introduced text messages between Charlie and Catherine Magbanoa from the weeks before the murder. The messages are mundane. They talk about going out to dinner. They talk about Charlie's car. They talk occasionally about Catherine's children. But there are also messages in which Charlie and Catherine discuss, in vague terms, the situation, in which Charlie asks whether our friends are ready, in which Catherine reassures him that things are being handled. These messages are not explicit enough to be a confession, but they are more than enough when combined with the financial records and the Rivera testimony to establish that Charlie knew exactly what Catherine was arranging and was paying her to arrange it. There is also a piece of evidence that I find particularly chilling. In the weeks before the murder, someone, the state believes it was Catherine, acting on Charlie's instructions, conducted internet searches for information about Dan Markel, searches for his home address, searches for his workplace, searches for photographs of him. These searches were conducted on devices that were later linked to people in Catherine's circle. The searches stopped abruptly in mid-July 2014, around the time Sigfredo and Lewis would have had all the information they needed. This is what a contract killing looks like when it is planned by people who are not professional criminals. It is sloppy. It leaves traces. It generates evidence that, years later, can be reconstructed by patient investigators. The Adelson family, for all its money and for all its lawyers, did not understand how completely the digital age had ended the possibility of a truly hidden crime. Every phone call leaves a record. Every text message leaves a record. Every financial transfer leaves a record. Every car on every Florida highway is photographed by a license plate reader somewhere. The belief on the part of a certain kind of wealthy person that they can arrange something like this and not be caught is a belief that belongs to an earlier century. During Catherine Magbanowa's retrial in 2022, a forensic accountant testified for the state. He walked the jury through, month by month, the pattern of payments from Charlie Adelson to Catherine Magbanowa in the months after Dan Markel's death. He showed the jury that Catherine, who had been a woman of modest means before July of 2014, suddenly began receiving checks of several $1,000s at a time on a regular schedule, supposedly for employment at the Adelson Family dental practice. He showed that there was no corresponding record of work performed, no employee file, no performance reviews, no patient records reflecting her involvement. It was a phantom job, a paper employment designed to justify the ongoing flow of cash. And the cash kept flowing for years, right up until the arrests in 2016. This, too, is how people who are not professional criminals handle the aftermath of a contract killing. They keep paying. They pay because they are afraid the person they paid will talk. They pay because paying feels safer than not paying. They pay because, having committed the original crime, they have no meaningful exit. Every payment becomes another piece of evidence. Every month of payments becomes another month of evidence. By the time Charlie Adelson was arrested, the financial trail stretched back almost 8 years, and it was as damning as any signed confession. Now I want to talk about something that has haunted me, as a storyteller, more than any other element of this case. I want to talk about what Dan Markel's sons had been asked to carry. The two boys were 4 and 6 at the time of their father's death. They are teenagers now. They have grown up with their mother, Wendy Adelson. They have grown up knowing that their father was killed. They have grown up knowing, as the years passed and the charges accumulated, that their Uncle Charlie was in prison for killing their father, and then that their grandmother Donna was arrested for the same crime, and then that their grandmother was going on trial. Their grandfather, Harvey Adelson, the dentist who built the family's wealth, has not been charged with any crime. He has publicly maintained his wife's innocence. He is, as of this recording, still living in the Aventura area, watching his wife be prosecuted for conspiring to kill his grandchildren's father. The paternal grandparents, Ruth and Phil Markel, fought for years to maintain a relationship with the boys. It was not simple. Ruth and Phil lived in Canada. The boys lived in South Florida with the family that, in Ruth's view, had taken her son from her. There were legal disputes over grandparent visitation rights. There were periods when Ruth could see her grandsons regularly and periods when she could not. Ruth fought, publicly and eloquently, for what she called her grandson's right to know who their father had been, to know what he had written, to know what he had stood for, to know that, whatever the rest of their family had done, he had been a serious and loving man who had been taken from them by people they knew. I do not know what those two boys carry now, as teenagers. I do not know what conversations they have had with their mother. I do not know what they believe about their uncle or their grandmother. I do not know how they understand the relationship between the father they lost and the family they have grown up inside. But I know that whatever they carry, they will carry it for the rest of their lives, and it will shape everything they become. This is perhaps the deepest injury that a case like this leaves behind. The victim is gone, and the trial can produce a verdict, and the verdict can produce a sentence. But the children of the victim are still alive, and the children of the perpetrators are still alive, and in this case, they are the same children, the same two boys. There is no verdict that fixes this. Let me return to the legal mechanics for a moment, because I want to make sure you understand how unusual this case is. Contract killings in the United States are not actually that common. When they happen, they are usually in connection with organized criminal activity. Drug dealers killing drug dealers, gang members killing gang members, occasionally a cheating spouse hiring an undercover officer who turns out to be pretending to be a hitman. What makes the Dan Markel case unusual is that none of the people at the top of the conspiracy were criminals in the ordinary sense. They were dentists, they were lawyers, they were affluent professionals who had never been arrested for anything before, and who, apart from this one catastrophic decision, probably would never have been arrested for anything in their lives. Contract killings also tend to go unsolved more often than other murders. This is because contract killings are designed, from the beginning, to sever the connection between the killer and the victim. The shooter has no personal relationship with the target. The shooter comes from somewhere else. The shooter leaves no motive trail. The person who ordered the killing stays far away from the scene. Under ordinary circumstances, the detective is stuck because the two people who have to be connected, the shooter and the target, simply have no relationship to connect. The Dan Markel case was cracked despite all of this for two main reasons. The first is that Sigfredo Garcia and Luis Rivera were not professional contract killers. They were street-level Latin Kings members from Miami who had been recruited for a job that was beyond their competence. They got caught on license plate readers. They got caught on rental car records. They got caught because Luis Rivera eventually bragged about the job to the wrong person. They were, in a word, amateurs. The second reason is Catherine Magbanua. Catherine was the connection point. She linked the shooters to the family. Her ongoing financial relationship with Charlie Adelson, those phantom payments from the dental practice, was the single most important piece of corroborating evidence in the case. Without Catherine in the middle, investigators would have had a contract killing with no path to the financier. With Catherine in the middle, they had a path. A long, slow, carefully documented path, but a path. And that path led, eventually, to a son and a mother on a wiretapped phone call, talking about Vietnam. I want to say something now about Detective Craig Isom and the team of investigators who worked this case for 10 years. This is the kind of case that careers are built around, but it is also the kind of case that destroys careers. Because for years it looked unsolvable. There were detectives who worked the Markel file for months at a time without producing a single usable lead. There were prosecutors who inherited the case from predecessors and had to decide whether to keep investing resources in a murder that most observers assumed would never be solved. There were FBI agents who had to be persuaded that it was worth running a bump operation on a 70-year-old grandmother in South Florida almost a decade after the fact. Every one of those people had to choose to keep working. Every one of them had to choose not to shelve the case. And when the convictions finally came in 2019 and 2022 and 2023, they came because a series of patient professionals refused to let the file die. This is not how most television crime dramas depict murder investigations. In television, detectives solve murders in 42 minutes. In reality, the hardest murders take a decade, and they are solved not by a single breakthrough, but by the accumulated weight of years of small, unglamorous, procedural work, pulling records, reviewing footage, running down leads that go nowhere, writing affidavits, flipping co-conspirators, waiting for a target to make a mistake. The Dan Markel case is one of the great examples in modern American criminal investigation of what that patience looks like when it succeeds. It also reveals what can happen when a case attracts sustained media attention. Local Tallahassee reporters, along with true crime journalists from around the country, kept writing about this case year after year. There were podcasts, there were documentary segments. There was a steady drumbeat of coverage that made it politically impossible for the state attorney's office to quietly shelve the investigation. Dan Markel's family, his friends, his academic colleagues, and a dedicated group of journalists made sure that the case remained visible. That visibility mattered. It mattered enormously. Now let me bring this home. Let me tell you what I, Miles, Ghost Hunter, take away from a case like this one. Because after telling stories like this for as long as I have learned that the facts are just the skeleton. The meaning is something else. The meaning of the Dan Markel case, as I read it, is this: evil, real evil, the kind that ends a human life, is almost never the product of a single monstrous decision. It is the product of a slow drift, a series of small accommodations, a family that does not say, quote, 12 when it should, a son who does not push back on a mother who does not recognize in herself the terrible thing she is starting to consider, a lover who does not refuse to connect the dots for the people who are asking, a pair of street-level men who do not walk away from a job they know is wrong. At every single point in the chain that led to Dan Markel's death, someone could have said no. Someone could have stopped it. Nobody did. And a 41-year-old father of two was shot in his garage on a Friday morning in July. This is why Dan Markel's scholarship matters, by the way. His work was obsessed with the question of moral responsibility, with the question of how we hold people accountable for the choices they make, and with the deeper question of how a community expresses its judgment that some choices cannot be tolerated. The state of Florida, in prosecuting this case, did exactly what Dan Markel argued the state had a duty to do. It did not manage the problem quietly. It did not settle for partial convictions. It pursued every person who had a hand in the killing, up the chain, one defendant at a time, for 10 years, until it had reached the top. That is what retributive justice, in the fullest philosophical sense, actually looks like when it works. It looks like this case. There is one more thing I want to say, and then I will let you go. Ruth Markel, Dan's mother, has said in interviews that the hardest part of the last decade has not been the waiting. It has not been the trials. It has not even been the verdicts, which came, one by one, years after she had almost stopped expecting them. The hardest part, she has said, is that her son is still gone, that no verdict brings him back, that her grandchildren are growing up without him, that a man who had so much left to write, so much left to teach, so much left to contribute, was taken from the world for the cost of a used car. She is right. No verdict fixes that. No prison sentence, no matter how long, restores what was lost. Dan Markel will not publish another paper. He will not teach another class. He will not see his sons graduate from high school or college. He will not see them get married. He will not meet his grandchildren, if they ever have any. The universe is smaller and colder and less thoughtful because he is not in it. But the verdict is not meaningless either. Because the alternative in which the Adelson family simply got away with it, in which Charlie went back to his dental practice and Donna went back to a gated community, and Wendy raised her boys in the shadow of a crime nobody would ever confront, that alternative would have been a different kind of ending, to be grateful for. It says that when someone like Dan Markel is killed, the community notices, the community responds, the community eventually confronts. Dan Markel would have appreciated that. I think, if he could see what has happened in the years since his death, he would have written a paper about it. He would have called it something academic and slightly pretentious. He would have argued, in his careful, footnoted way, that the Florida prosecutors had demonstrated something important about the moral logic of criminal punishment. And he would have been pleased, in a quiet, scholarly, Dan Markel kind of way, that his own death had become the case that proved his own theory. That is the kind of man he was. Miles Ghost Hunter, signing off from the Dan Markel case. A law professor, a father, a scholar. A man who spent his life asking the hardest questions about justice, and ended up, without ever intending to, answering them with his own death. If you made it this far, you know what kind of stories we tell on this channel. We do not sensationalize. We do not exploit. We do not pretend that any of these cases are entertainment. What we do is take seriously the lives that were ended and the families that were left behind. We tell you what actually happened, as carefully as we can reconstruct it, and we try to draw out the meaning that the facts reveal. Dan Markel was a professor. Our next defendant was a writer, a novelist. A man who had made his entire living writing about crime and fiction, until the night he had to explain, in his own kitchen, at the bottom of his own staircase, what had happened to his wife. The case is Michael Peterson. The place is Durham, North Carolina. The staircase is one of the most famous staircases in the history of American true crime. And the question, at the center of it all, is whether the man who wrote about death for a living had finally written his own masterpiece in blood. That is episode 10. Do not miss it. Until then, keep your doors locked, keep your eyes open, and remember, in this kind of world, the people closest to you are statistically the people most likely to end your life. Dan Markel learned that the hard way. You do not have to. This has been Miles Ghost Hunter. The case of Daniel Eric Markel, 1972 to 2014. A law professor at Florida State University, a father of two, a scholar, a teacher. A man who is still being read, still being cited, still being argued about in law school classrooms around the world. Still, in every meaningful sense, present. Rest easy, Professor. Your case closed, your theory held, your students learned. Good night.